Justices have said for the first time, former presidents can be shielded from prosecution for at least some of what they do in office. Former President Trump faces 3 charges of conspiracy and 1 count of obstructing an official proceeding. They're all related to his role in the January 6th insurrection and his efforts to stay in office after his 2020 presidential loss. The justices sent the case back to a lower court, which will decide how to apply the ruling to his case. The ruling guarantees the former president will not be tried before the November election. Shortly after the ruling, Mr. Trump posted on his social media platform, quote, "Big win for our Constitution and democracy. Proud to be an American."
WGN political analyst Paul Lisnek joining us now to explain a little bit more about this ruling.
Good morning, guys.
Good morning. The Supreme Court asking this lower court to distinguish between official acts and unofficial acts. What does that mean? How does it impact Trump's case?
Well, so the reason they did that was they made the point of saying nobody has ever ruled before about a distinction between official acts and unofficial acts. And they go on to say, by the way, because they probably knew they'd take some criticism on that. And by the way, the way this case came up to us, it also didn't specify which acts were official and not. Here they said because the lower courts just expedited this thing so quickly and moved it so fast, it wasn't dealt with. So now we've got to address those. They'll send it back to Judge Tanya Chutkan for her to make those determinations. But it's tricky, if I may just go on to say it, because one of the things they say is, first of all, when we're talking about an official act, Chief Justice Roberts says in his opinion, he goes, that includes the outer perimeter of the official duties of the president. And it says it doesn't have to be manifestly or palpably beyond. It's a wide scope. And something else really tricky, not a lot of people are talking about yet, which is the court cannot inquire into presidential motives. So when a president does something, and it's considered an official act, you may not use those, you may not question his motive, nor can you enter into evidence in any kind of prosecution, anything that was official. So it seems they would tell you it's somewhat narrow. It's not. It's a very broad ruling.
So on the last day, this ruling coming down.
They save the biggest for the last.
Yeah. How much time might it take for the lower courts? I mean, clearly not going to happen before November.
There will not be a trial before November. What could happen is Judge Chutkan now has her marching orders. And so she could say, okay, let's do what we got to do. Let's talk about what's official and what's not official. Now, she could say, let's begin a briefing schedule. Let's do this whole thing. We'll have hearings. We'll do all of this. That can take many months. But Judge Chutkan wanted to try this case. So what I think she may do is to say, you know what? We've got enough in the record already for me to make those decisions. Or she may say, I just want you to brief it, but I'm prepared to move with this fairly quickly. So we will see. However, whatever she decides will then get appealed by the Trump team. So my point is, for voters who say, I wish I could know something before I vote, they may get some evidentiary hearings which will put some stuff out there publicly, but it won't go further than that because the appeals will begin.
Trump obviously claiming this is a victory for him because it kicks the can down the road.
Well, that's his main goal, and he got
the election.
Yeah.
So if he is elected president again, can he make this all go away?
Yes. Because he will simply have a new attorney general, and he will instruct the attorney, even though it's supposed to be independent, he will instruct the attorney general to make these go away. Any attorney general will be a Trump loyalist, right? So they will make this case go away anyway. By the way, this raises questions in all the cases going on with Trump, because they're now going to renew their calls for presidential immunity. They were given some meat here, right, of immunity. They will now ask all the courts to say, hey, whatever it is you think I did in your case, that's part of what's covered as official acts and official immunity. So he will probably get some time in almost everything here. Might even get previous cases that have been, New York and whatever, and ask those judges to review.
And if the election is close, it clearly emboldens him for what might happen again.
Without question.
Quickly, I know you wanted to talk about Justice Thomas.
Yeah, this isn't getting a lot of play, but one of the things Justice Thomas says in his concurring opinion, he says, and by the way, Jack Smith, is that appointment valid? I'm not so sure this special counsel was validly appointed because the people didn't get to speak. What makes that especially, now that's a concurring opinion, it's not law, but what's especially interesting about that is that Judge Cannon in Florida is having hearings on that very question now and getting mocked for it because this issue of appointments of special counsel, that comes up from time to time. They've always been rejected. The challenges have always been rejected. Special counsels are accepted, but now it's interesting. It gives Judge Cannon a little rule to say, hey, look what even Thomas suggested this as well. We'll see what happens there, but that's something that needs to get looked at. And the dissenters, by the way, notably did not say, I respectfully dissent. In fact, Sotomayor said, with fear for our democracy, I dissent.
Oh boy. Okay.